Grazie. All right, okay. So good afternoon, ladies and gentlemen, and thank you very much for attending this panel. I mean, competition out there is very tough because, as you know, there are a couple of simultaneous panels ongoing, and very interesting, by the way. So your presence here is all the more appreciated. I'm Mario Todino, Jones Day, and I will be moderating this panel that, as you know, is devoted to territorial supply constraints, how to address them through enforcement, through legislative intervention. We'll be discussing pros and cons of all these aspects. As to the format, we are actually going to have a debate structured along questions and answers in order to avoid, flat and boring presentations. And of course, we'll make sure to reserve some time for questions at the end, right? Now, let me introduce our speakers, two great speakers. On my right, we have Alberto Aimler, who actually needs no introduction. He's one of the most authoritative voices in the competition debate. He's been for decades the head of the Bureau for Economic and Legal Studies of the Italian Competition Authority. He has actually an outstanding production of scientific contributions to the debate. He's chairman of a OECD Committee for Competition Regulation, professor at university, and more importantly, very knowledgeable of the topic. And then we have, on my further right, Alberto Martinazzi, who's head of international competition in Coca-Cola, and formerly in private practice with Gianni Rigoni, where we actually had the pleasure to work together, and then Herbert Smith. All right, so now let's, regarding very briefly the format, the plan, so what we have on the program, okay? The discussion will be split, I would say, in two parts. First part, we're going to discuss the enforcement, okay? So whether the enforcement is appropriate, is sufficient, whether we have the impression that, that it's becoming increasingly aggressive, and whether the bar for intervention is being lowered or risks of being lowered. And then the second part, the second part will be devoted to, territorial supply constraints in the proper sense, whether there is indeed a need of, legislative intervention, or what are the side effects, what are the pros and cons. And so having said all that, I think let's start. And to set the stage, of course, as I said already, what are these territorial supply constraints? This is a relatively novel terminology, right, which actually covers a number of commercial practices adopted by suppliers of consumer goods, mostly, right, vis-à-vis distributors and retailers, which can have as an effect, direct or indirect effect, some form of restrictions to sales towards countries where prices are higher within the EU, okay? So typically we would have various forms of refusal to deal. We will be discussing that, at length in a short while, or pricing differently depending on the country of the EU because of the purchasing power of the consumers, because of the costs as well, obviously. And then labeling and packaging depending on the national requirements, which also may end up in restrictions, right, to intra-community trade. Now, having said all that, why they are now important again, why there is so much attention on these TSCs? Of course, because you might have followed, right, that there is a lot of emphasis on the fragmentation of the internal market, single market, Letta report, Draghi reports, insisting and emphasizing the fragmentation of internal market. Something has to be done, and this is why now these territorial supply constraints are on the radar screen of the legislator, so the lawmakers, and also of the enforcers. Okay? So, but as I said, let's start with the enforcement, okay? Because, of course, it's the most compelling thing that we are in the private practice, and you probably, there are people in the business, right? You're faced with, you have to face these constraints and understand actually where we stand, where are we heading. But before doing that, I think it's interesting, okay, to have an historical perspective of this type of enforcement. So here we're talking about the enforcement vis-a-vis practices restricting parallel trade, okay? So these practices have been combating by the Commission for decades. 40 years. For 40 years. Actually, there was, so the integration of the internal market was indeed the primary concern of the European Commission. The problem, though, so for decades, actually, the Commission cared and was concerned by, actually, competition rules being applied to fight parallel trade. And everything was actually, in a way, vitiated by this original sin. Alberto, perhaps you vividly recall what happened in the time. We're talking about, you know, the 70s, the 80s, the 90s, where the Commission actually was concerned only by intra-brand competition, because intra-brand competition, of course, entailed, you know, parallel trade, and therefore everything was actually influenced by this peculiar approach to the problem. Please.
Yes, indeed. The first two block exemptions regulation that the Commission issued in 1983 were Regulation 82 and Regulation 83, both concerning, one concerning exclusive dealing, the other exclusive purchasing agreements, implying that this was the most important element of EU antitrust. Parallel trade, intra-brand competition was at the forefront of the initiatives of the European Commission. And if you read the legal provisions, both Article 102 and Article 101, they have exactly the same language. What is prohibited is applying dissimilar conditions to equivalent transactions with other trading partners, thereby placing them at a competitive disadvantage. But this last part, this competitive disadvantage, was really not so much considered. What was considered very important was the fact that member states were subject to some sort of private restrictions, and what the Commission was aiming at impeding was that private parties would not reintroduce privately the regulatory restrictions that the Commission has dismantled, that the European Union has dismantled through the internal market rules. Indeed, I checked all the cases of the European Union in the past 70 years, and there is no one where the Commission enforced the law against price discrimination which did not entail an absolute territorial restriction. So price discrimination is okay at the European Union level as long as it does not imply a market segmentation of member states. And I checked even cases where of abuse of dominance. For example, Compagnie Maritime Belge, which is a joint dominant case, 1996, there was price discrimination. There were fighting ships that the conference was introducing in order to stop competitors entering the market. And indeed, it was this foreclosure effect that was attacked by the Commission. It was not the discrimination itself. And I checked even US cases, the very famous Kellogg case of 1982, which started indeed the debate in the antitrust world, which led to considering price discrimination efficient. Even that case was a case that was constructed around foreclosure. Kellogg, which is the major producer of cereals, was multiplying brands, low-cost brands, according to the theory that FTC put forward, was introducing low-cost brands that would impede competitors from entering into the market and making a name for themselves. So also that one was a foreclosure case, not a price discrimination case. I say this to imply that price discrimination is well okay at the European Union level. We never had a case against airlines that price discriminate. We never had a case against rail services which price discriminate. We always have cases where price discrimination is associated with some sort of territorial restrictions. And as a result, this idea of absolute territorial restrictions becomes like the idea that absolute territorial restrictions are to be prohibited becomes like a constitutional issue within the European Union, and the efficiency considerations are quite rare. Maybe in the next round I can say something about these efficiency considerations. They do exist, but in my view, they have to be argued within the internal market framework, not within an antitrust framework. Because all this, whenever the Commission is questioned about these cases, they always say, well, these are cases that they are not really antitrust. These are internal market cases, just to block the debate and to stop us debating efficiency.
Yes, indeed, indeed. And to complete on this point, why I think it's important to look at the past, right? And there are lessons to be drawn. Because after all, there were damaging, very damaging side effects as a result of this pollution, if you like, this misunderstanding of the ultimate objective of antitrust rules. So for many years, this problem caused, a lot of problems in terms of wrong enforcement priorities, in terms of misunderstanding of the ultimate objective of the antitrust rules, because there was no effect analysis, so it was entirely formalistic, an oversized overexpansion of the scope of the prohibition rule, which then required exemption, which was monopolized by the European Commission, which caused a traffic jam in terms of request for exemption, which then in turn generated, a string of block exemption regulation. So I think that we need to, and then in the late 90s, this situation changed because there was the reform of the vertical restraints, the effect-based analysis, and so on and so on. But what I'm trying to say is that we need to pay attention, because when we we inaugurate a new course, okay, with a special law, we stretch the boundaries of the law, we end up with, strange animals that can be applied all over the place, including by national competition agencies, to be watched, and then you end up with Frankenstein. Having said all that, let's come back to the present and see where we stand. So in terms of enforcement, okay, when it comes to these restrictive practices of parallel trade, Alberto Martinazzi. So where do we stand in your view? Because there we have a recent practice, right, of the European Commission, clearly identifying, and there's nothing new. But there is a long list, right? How do you see that?
Yes, Mario, thank you. We have two cases. Okay. Yes, we have two cases that have traced the new line of enforcement of the European Commission. One is AB Inbev, and the other one is Mondelez, and they both concern consumer goods. They are both Article 101 and Article 102 cases, but interestingly, Mondelez has 22 counts of Article 101 and only 2 counts of Article 102. So it's essentially a 101 case. And that is because the company had in place contracts with distributors that had either destination clauses, so restricting the ultimate destination of the goods, or mechanism through which the distributors would have to report back to Mondelez if they receive any requests from buyers outside of the territory, so a monitoring mechanism. Or there was dual pricing in place, so Mondelez knew in advance who was going to buy, and therefore they would apply the domestic versus the export price. So these were found to be outright anti-competitive under 101. And then there is the classic refusal to supply, which happened with regard to a trader, in particularly based in Germany, that wanted to import Oreo cookies and Milka bars, chocolate bars, from Slovakia into Germany. Germany being the contestable market where Mondelez didn't have a dominant position. So they were trying to protect the more challengeable pricing in the market where they obviously would have suffered most from cheaper prices. And again, there was a pretty relevant evidence of this behavior. So there was internal documents, and even internally in the company there were a moniker of the Germany taboo, meaning we need to protect Germany. So there was very striking evidence in this case that the company had put in place restrictive measures over the years, over many years. AB Inbev is an interesting one because alongside the traditional contractual levers, you also have new theories around packaging differentiation. So especially on occasion of events like the Football World Cup, these are very common with consumer goods. I mean, you will see, Olympics and Football World Cups and so on. You will get special edition cans or special edition packaging for companies that are obviously sponsoring, investing multi-million budgets into these events. And in the case of AB Inbev, they had signed up the sponsorship of the Dutch national football team. So they thought well of changing the color of Jupiler beer. Mario, you are based in Belgium. You know that Jupiler is a very popular beer in both Belgium and the Netherlands. And so they removed from the labels the French language. It was just a label in Dutch, entirely Dutch. And that caused a big stir in the market because all the traders that were purchasing Jupiler beer in the Netherlands, where it was cheaper, and reselling it into Belgium, suddenly had no stock for a very, very important part of the season. Obviously, the Football World Cup, everyone drinks beer. And, the evidence is crucial here, the evidence and the intent, because there was evidence that AB Inbev was clear that this would not only help with their promotional marketing campaigns, but also stop that parallel flow. And so they found emails and other documents that said, let's go full Dutch and paint the cans orange. And so that also has the benefit of preventing these traders from selling into Belgium, where, of course, Jupiler trades at a much higher price. So that's one example of, novel enforcement. To my mind, before AB Inbev, there's not been any clear reference to differentiating packaging. And in Mondelez, the Commission said they found something around differentiated packaging, but clearly they had stronger evidence. So in the end, they didn't feel they had to push through with this additional theory of harm. If you allow me just to say one thing, I mean, packaging differentiation and pricing differentiation is really key in all consumer markets, and it stems from, first for packaging differentiation, big in spending on understanding consumer preferences. So that's what drives brands. Brands are driven by spending, understanding what the consumer wants, and putting money into, of course, marketing that goes that way. And you'll be surprised what this data show you. It shows you that, in some countries, the paprika chips sell more if the packaging is red. In some countries, the paprika chips sell more if packaging is blue. right? And so as a manufacturer of paprika flavored chips, you go with that. And to be then told that this is a way of restricting parallel trade, this is what often our commercial colleagues are like, well, no, this is not the intention. Intention was to meet the consumer demand. And I think the key point from this case is really the intent, right? So you have evidence that there was a clear intent to restrict parallel trade.
If I may add just one comment to this, is that usually these cases originate from a change in the commercial practices, as you mentioned. Before, there was Dutch and French, then it was only Dutch. Yes. I'm not sure that the case would have been brought had it just been French and Dutch only all the time. So it's the question of change that drives the antitrust authority to step in, besides the effect on which I agree that they don't do any effect analysis. But I wonder whether this induced the Commission to take up the case.
Which might be also an indicator of the intent, right, of when building the theory of harm, sure. Right? Because what we see...
Otherwise, how can you build the intent?
Exactly. So in all these cases, in a way, the Commission has always been applying, right, a theory of harm where there was a plan, an overall plan. Although now we see, obiter dicta, perhaps in the two decisions, stating that even one conduct, sporadic, whatever, could actually result into an anti-competitive behavior. But then, indeed, there is always this construction that they go and try to prove that there is a plan. So there must be, several indicia militating in favor of this test. So just to complete here, and then we will come back, because I propose that we draw the conclusions about enforcement versus legislative intervention at the end. For the time being, I mean, we don't see, do we, a very a stretching of the boundaries of the law in the past practice. So it's very much along the lines. Okay, of course, the Commission has modernized this practice, has pushed for further this idea that any financial incentives indirectly designed, right, to discourage parallel trade should be challenged, but we don't see like revolutionary applications. Then we will come back to this later. Now, if we turn to the territorial supply constraints in the proper sense, so the other debate, right? Because as I explained at the beginning, there is this debate about all these commercial practices, which are actually, are actually lawful. So you have a small subset of practices which are already actually can be attacked and challenged based on enforcement. And then you have, okay, a panoply of commercial practices which are actually lawful at the moment, I would say, and they are being challenged in the public debate. So what do we do with this? And Alberto, perhaps again, if you tell us, so there are 2-3 categories, right, of typical...
Yes, so the debate starts in the dawn of days, but it really starts in 2020 when the European Commission has a study published that is, in my view, in the view of the consumer goods industry, is a very flawed study, unfortunately, because it was a sample of 34 retailers all over Europe, representing 0.01% of the 5.5 million retailers out there. And they say that there are some territorial supply constraints, and these territorial supply constraints, if removed, could save European consumers up to 14 billion euros annually, which is a huge number. And that was quickly seized by politicians, by lobby groups, and it's what is really driving this debate now, because we are in the age of the cost of living crisis, and inflation-driven pricing. And the issue we have is that this has become the narrative in many capitals across Europe, especially in countries that feel they are losing out to bigger member states in terms of market competition. So we're talking about smaller member states, of course, peripheral member states, where obviously the supply chain has to be inevitably less developed than in countries like Germany, France, in the center of Europe. And there's a big political push at DG GROW, which is the enterprise heart of the European Commission, to come up with some tools to deal with these TSCs. But back to your question, what are TSCs? I mean, we have a hard time understanding ourselves what is this all about. Effectively, you have two buckets, let's say. One is the sort of like indirect means to sort of make parallel trade harder. And we've already mentioned some of these, like different packaging, different colors on packaging, different labels, which, let's be absolutely clear, they stem from regulation. We have 27 different labeling regulations in Europe. Each member state has its own. So there is complete lack of internal market harmonization. And then there are other regulations that mandate what has to go on the label, and obviously brand manufacturers are liable for compliance, not the retailers, not the distributors, not anyone in the supply chain, but the manufacturers. So that's important context, because there is, I think, as a first answer to some of these allegations, there is a big rebuttal, which is we need to fix the internal market harmonization first. And there are things moving in this space. For example, the recently adopted packaging and packaging waste regulation, which is going to harmonize how single-use plastic, like wrappers on products, plastic wrappers, and recyclability will have to be handled with the use of pictograms and standardizing packaging. So there is really a question: do we need more regulation in this space, or should we let the existing regulation, especially around sustainability, recycling, which is a big push, work its way through and facilitate that market integration and product circulation? So I think, as I said, there is also another important aspect. I think the professor just also mentioned this, which goes back to, price differentiation is ubiquitous, right? And it has good logic in that if you produce locally, you bear the costs of producing locally. So just to give an example, in Italy, the Coca-Cola system employs directly or indirectly 30,000 people. And if we have to produce in a lower cost country within Europe, those jobs will be gone. And that would happen all over Europe, right? If those price dynamics change structurally. So I think there are a lot of moving parts here that need to be reconciled. On the one part, you have the technical arguments about these TSCs around packaging and labeling, but what is really masking is a political desire to have uniform pricing and the ability to purchase everywhere in Europe at the cheapest price, which is a dream of the parts of the supply chain, especially at the far end of the supply chain, the retailers.
Alberto Aimler, how do you see this, especially the price discrimination? Because, economists are very fond of price discrimination, right?
Well, price discrimination is efficient insofar as it leads to higher volumes. It's not that economists don't recognize that sometimes price discrimination can be welfare reducing. Price discrimination can be indeed welfare reducing, but it may also be welfare enhancing, and what we have to see is whether the price discrimination leads to bigger quantities. And this is the big test that we have to pass in order for it to pass a consumer welfare test, if you want. But having said that, I repeat what I said before, that absolute territorial restrictions have been prohibited in Europe not because of efficiency. They have prohibited just for the reason that my co-panelist just mentioned, that is the idea to create, through the prohibition of absolute territorial restriction, the internal market. We haven't succeeded so far, and maybe we will never succeed in the future to indeed arrive to the internal market, but it's a political push. Having heard what you said about developments at the European level, certainly one very positive solution could be to harmonize all those requirements, labeling requirements that you say are spread among the sovereignty of 27 member states. And if that would be at the European level, of course, all these questions would be less important. So I'm sort of optimist that we will not go to a blank imposition of elimination of sort of restrictions on packaging. It's much better to start from the top and eliminate all these differentiations. As for what happened in the past, I agree with you that a lot of resources have been wasted, but the most serious mistakes, that is, the mistakes that were done in the pharmaceutical industries, have been remedied at the end. And the court understood that an absolute territorial restriction is necessary when you have price regulation that differs across member states, and you have jurisdictions with a lower ability to pay, where drugs, pharmaceuticals are priced at a lower price than other jurisdictions with a higher ability to pay. And after many cases, it is clear now that such imposition of parallel trade in such circumstances is welfare reducing, not certainly welfare enhancing. So there have been development favoring some flexibility. Now, I don't know if we will go towards the consumer goods industries. It can be done on investment goods in some cases. It can be argued. I think it's going to be difficult to argue the same for consumer goods.
I think, when it comes to labeling and packaging, as you said, it would make sense perhaps to have, but I think, I'm not an expert. I think there are directives in the labeling and even in the packaging. The thing is, they secure a minimum harmonization.
Yes.
And there you have all over the place member states deciding on their own.
You have member states on label even imposing mandating minimum fonts. So in some countries you have to write bigger labels, right? You have less space on the label because the law requires a minimum font.
Italy is even under an infringement procedure because of...
Italy, France and Spain are all under infringement procedures on this. So,
why?
Because they are not complying with the minimum harmonization requirements that they are still insisting on their national laws.
Then how would actually a piece of legislation, regulation look like when it comes to price differentiation? So what would be...
Well, the idea in Brussels is that you wouldn't push directly for price harmonization. You would basically shift the burden of proof on brands and consumer goods as to why they charge different prices. So almost like flipping the burden of proof. Right now, you could refuse an order and say, well, I don't have capacity, or you don't need to justify it, just redirect a buyer to the local supplier. Going forward, this in the idea of some, this could be flipped, and it would be the duty of the suppliers to justify why they fall within a very narrow number of exceptions to the general rules that they have to supply at the price at which they are selling to domestic buyers. So indirectly, you are achieving a pricing uniformity through a mechanism that restricts those exceptional circumstances to the very minimum.
But we would end up with what price then?
Well, that's the question, because of course it wouldn't be that price anymore, right? It would be another price.
Yeah.
And the consumers in those markets where the prices are currently cheaper would lose out. And their disposable income is obviously much lower. So if you look at countries like, well, Italy, unfortunately, Greece, or other countries, Bulgaria, Romania, compared to Germany or France, of course, disposable income is lower. So you would end up with even more inequality in the European Union.
All right.
Somehow, if I understood correctly the case law, it already started. There is this clear stream case where it was an abuse of dominance based on price discrimination. That is, there was a differentiation between a French customer and all the German customer of the clearing house of security in Germany. And the Commission said that this is an abuse of dominance without any proof on effects, on anti-competitive effects. So it's already going a little bit in that direction.
Right. I think that now let's come back to the original question, right? So, how do we address whether there is indeed? So we see that there are indeed a number of counter-integrations to legislative intervention. We will see what happens. But indeed, I think there are indeed some side effects that should be carefully contemplated. But then when it comes to the enforcement, because of course there is this temptation to go for a more aggressive enforcement. We do see already an increasingly aggressive enforcement of the Commission in this space to fill the gap. Okay. Then my question, right? So do we run the risk of ending up with monsters? Because after all, here we have, for instance, practices that probably would be qualified as refusal to deal, price discrimination, of course, without any exclusionary dimension whatsoever. So don't we run the risk of having at some stage cases where Commission will start, attacking, I don't know, a refusal to deal with the distributor in Lilliput, requiring tons of volumes of Coca-Cola for the whole of the EU, and getting a straight refusal to deal, and then we run the risk of having a United Brand style type of refusal to deal, or price discrimination likewise, and then what happens to these monsters once they are out?
Obviously, I mean, you expect my answers, right, on this. Well, the monsters, I mean, the animal spirits are out, unfortunately. I mean, we have seen last month the Austrian government and the Austrian competition authority co-signed a letter to the Commissioner Ribeira asking for intervention on prices in the consumer goods space. So I think in a way the ship has sailed. But back to your question, so we do have a good framework in place with these cases, AB Inbev and Mondelez. They're very clear on what is wrong and where the line in the sand is, right, in terms of unlawful conduct. And DG Comp themselves, they are reluctant to push this debate into technical competition law realms. At the same time, I think they will feel the pressure. They will feel the political pressure. And so I worry that novel theories will spring, like packaging differentiation, perhaps disjoint from intent, which would be worrisome. And of course, anything that has to do with miscasting legitimate local price negotiation, which again are based on costs that are borne locally. Yeah, raw materials, energy costs, labor costs, you name it, transportation costs. Recasting them as a hindrance to parallel trade, because, as you say, in the case, you made a very, very valid example. I mean, small country, distributor, all of a sudden wanting to buy the whole demand for that country, which is big in proportion from another market, and that goes straight to redefining business models. We are no longer in the space of protecting parallel trade and market integration, but forcing on companies the obligation to redefine their business models around totemic ideas that again, and I'm not an economist, but I think ultimately would not result in consumer welfare.
No, they don't result necessarily. No, this for sure. But again, the idea of the Commission is not consumer welfare. Their idea is to create the internal market. And so I don't know what will be the future development. Looking at the cases, both recent cases, Inbev and Mondelez, which are the most recent one, they look to me very traditional cases. And they go along the lines of Glaxo, in a sense that they would impede companies circumventing the absolute territorial restriction by limiting quantities to be sold to a given distributor. So I agree that a distributor in a low-cost country, for example, had he or she would purchase the whole supply for Europe, would be a bit would change the behavior. If that would be possible, it would change the practice of the company. But I don't think those are the arguments that would change the Commission policy, because the Commission knows very well. As I said, there are no pure price discrimination cases in EU antitrust. So they are all around absolute territorial restrictions, implying that it is this subdivision of the EU market, the internal market, that matters. Since I didn't say it, I want to add that the Robinson-Pacman Act indeed had the same objective of the EU treaty. The Robinson-Pacman Act prohibits price discrimination across state lines in the US. And it could have gone in the same direction as in Europe. And instead, it did not. I looked at recent cases that the FTC brought against companies enforcing the Robinson-Pacman Act. And they are all cases of unfairness with respect of small distributors. So the idea is that small distributors would purchase goods at a price where large distributors sell. And as a result, they would be put out of the market. And these were the cases where indeed you can see there is a competition effect. While in Europe, these competition effects are non-existent. They're not even required at the end.
Floor for questions and comments. We have 5 minutes or even more. Are there any comments or questions that you would like to address? Please.
Hi, I'm Rashid Baxter from Global Competition Review. I was just hoping to follow up on what you, Alberto, were saying on the follow-on from the Mondelez and AB Inbev cases in terms of DG Comp's response. Am I correct in understanding that your comments were about pressure on DG Comp from member states following those cases to explore further, perhaps theories of harm surrounding after those cases? Did I understand you correctly, or what was
Yes,
the message?
let me just reframe it a bit. So Mondelez, of course, was a big news in last year. The case, obviously, because of the fine. The fine was huge, right? 300 million euros, huge for these markets, obviously not for the tech markets, but large. It was seized by retailers as an example of more needs to be done in this space. And on the back of the study that I mentioned, 2020 study run by DG Grow, okay, another body within the European Commission, they kind of pointed, it was a rallying point for everyone, right, that is concerned with the cost of goods. Somewhat mischaracterizing the case, because these practices happened a decade ago. So, and of course, as we've been debating here, they were textbook type infringements. But that gave renewed vigor and momentum to the cry for more regulation in this space. So now the convergence we see is that politicians in some countries are being somewhat misguided by these voices to go on the price uniformity / price regulation type of approach. And that is, again, is worrisome for the reason that we've debated today. But it's resulted in the European Commission including territorial supply constraints in its single market strategy that was published in May 2025, so a few months ago. as an area where more tools are needed. Now, obviously, what that means is up for anyone's guess. A debate is ongoing in Europe with all the stakeholders involved. We think we have as an industry, we think we have a good argument to explain that there are already good solutions in place that will smoothen to a large degree these differentials. And I mentioned the packaging regulation, which again, it needs to be implemented. And there are technical aspects that need to be defined. Again, you could see fragmentation happening at the technical level that would somewhat kill these benefits. So we are again warning the stakeholders that in a correct implementation of the regulation technical aspects is very important, because it will end up streamlining many aspects of packaging that these days are called as potential indirect territorial supply constraints. And then another solution that's been put forward is digital labels. Now, of course, digital labels are not a perfect solution, because you would access all the languages through a QR code. There is a part of the population that still hasn't got, well, for good reason, access to smartphones, right? So you need to obviously protect those consumers. So it's imperfect, but it's at least a great advancement, I believe, in making sure that the products can be, again, this allegation that labels are somewhat restricting trade would go away. And these points are not duly considered in the debate. It's being, overshadowed by some populist voices, I'm afraid, at this point. And look, we are sympathetic as an industry to the plight of high consumer prices. But one important point in this debate is that, as we mentioned, not necessarily having cheaper wholesale prices results in lower consumer prices. The retailer may just pocket the difference and have higher margin. So there has to be as well a mechanism that guarantees consumers would benefit from cheaper prices. And the evidence to date is that supermarkets already price discriminate on their own private labels. In countries, even within, there's evidence that within Brussels, as you know, private labels in certain neighborhoods of Brussels are cheaper or more expensive than in others. So, it's a tricky one, because the retail industry has paint themselves as the holier than the Pope, and in practice is a much more fragmented and complex landscape.
What was the Austrian request?
The Austrian request to Commissioner Ribera was to basically see whether competition law and could do more to push for price convergence. The concern in Austria is that they share the same language with Germany, and there is a big price differential in some markets between Germany and Austria.
So Austria is higher?
Yes, much higher. They call it the Austrian surcharge, saying why are we paying more than our neighbors, the German neighbors? There are historical reasons for this. It applies to all the industry, all products in Austria. For some reason, the supply chains have been built in a different way to Germany. But even large German and Austrian distribution groups, they price differently in Germany and Austria. So it's a broader, more ingrained issue than just, consumer goods.
Other questions or comments? Hi.
No, you have to push.
Yeah, it works. Thank you. I have a different view when it comes to Mondelez, because you said the member states might be behind this. But as far as I remember, Mondelez was, 1, a settlement case, and 2, a leniency application.
I'm not aware of the leniency application. It was a settlement case for sure.
It was a settlement case because I remember we were involved in the case,
yes.
And as a national competition authority, it was rapporteur of the advisory committee. So, and the lecture that you gave to the case is a bit different from what we got from the Commission side. So, of course, it was a case that the Commission had to deal with.
Yeah.
No way about it. No doubt about it, sorry. But there was not a will, I think, from member states to push the Commission to deal with it.
No, well, maybe I didn't express myself properly. I mean, on the back of the Mondelez case, this push has come. So the Mondelez case was, as far as I know, launched ex officio by the European Commission. So they have done their own market intelligence, they came up with some indicia that there was a problem with Mondelez practices. Yeah. And then Mondelez settled. Yeah, that's correct. But what I meant is after Mondelez, there was a big push by the industry, by the retail industry, and again, which found listening ears in their politicians, because obviously they want cheaper prices. So that's the kind of the turn that this has taken after Mondelez. In terms of these enforcement cases, as far as I know personally, I think these have been run by the European Commission, DG Comp, based on their own market intelligence. I'm not aware of leniency applications of sorts. Yeah, no, exactly.
The evidence was straightforward.
Yes.
So that was, it seems to me quite strange that somehow member state could be behind this case.
Oh, no.
Because,
all right. No, they wouldn't be behind the case, no.
Sure. Thank you.